Criminology Board Exam Reviewer. Criminal Procedure. Definition of Terms. Part 2. Doctrine of Supervening Fact. It states that where after the first prosecution a new fact supervenes for which the defendant is responsible, which changes the character of the offense and, together with the facts existing at the time, constitutes a new and distinct offense, the accused cannot be said to be in second jeopardy, if indicted for the new offense. Provisional dismissal. It contemplates that the dismissal of the action is not permanent and can be revived within the period set by the rules of court. Time bar rule. It states that if no revival of the case is made within the prescribed period, the dismissal shall be removed from being provisional and shall become permanent. Pretrial. Pretrial is a procedural device intended to clarify and limit the basic issues between the parties and to take the trial of cases out of the realm of surprise and maneuvering. It thus paves the way for a less cluttered trial and resolution of the case. Pretrial Agreement. All agreements or admissions made or entered into during the pretrial conference shall be reduced in writing and signed by the accused and counsel, otherwise the same cannot be used against the accused. Pretrial Order. It is an order issued by the court reciting the actions taken, the facts stipulated and the evidence marked during the pretrial conference. Appellate Court Mediation, ACM. It is a mediation program in the CA, corollary to CAM in the lower courts. It provides a conciliatory approach in conflict resolution. Through ACM, the CA promotes a paradigm shift in resolving disputes from a right-based, judicial, to an interest-based, mediation, process. Trial. It is the examination before a competent tribunal according to the laws of the land, of facts put in issue in a case for the purpose of determining such issue. Hearing. Hearing is not confined to trial, but embraces several stages of litigation including the pre-trial stage. A hearing does not necessarily imply the presentation of oral or documentary evidence in open court but that the parties are afforded an opportunity to be heard. Continuous trial. The trial once commenced, shall continue from day to day as far as practicable until terminated. However, it may be postponed for a reasonable period of time for good cause. State witness. He is one of two or more persons jointly charged with the commission of a crime but who is discharged with his consent as such accused so that he may be a witness for the state. Demurrer to evidence. It is an objection by one of the parties and inaction to the effect that the evidence which his adversary produced is insufficient in point of law to make out a case or sustain the issue. Judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition of the proper penalty and civil liability, if any. Promulgation of judgment. It is the official proclamation or announcement of judgment. It is promulgated by reading it in the presence of the accused and any judge of the court which it was rendered, or when the judgment is one of conviction for a light offense, in the presence of the accused's counsel or representative. Final order. It disposes of the whole subject matter or terminates a particular issue leaving nothing to be done but to enforce by execution what has been determined. Interlocutory Order. It is issued by the court when the proceeding is not yet terminated because not all matters of the proceedings have been finished. Entry of judgment. The recording of the judgment or order in the Book of Entries of Judgments shall constitute its entry. The record shall contain the dispositive part of the judgment order and shall be signed by the clerk, with a certificate that such judgment or order has become final and executory. Motion for new trial. It is the rehearing of a case already decided but before the judgment of conviction therein rendered has become final, whereby errors of law or irregularities are expunged from the record or new evidence is introduced, or both steps are taken. Motion for reconsideration may be filed in order to correct errors of law or fact in the judgment. It does not require any further proceeding. Recantation. It is when a witness who previously gave a testimony subsequently declares that his statements are untrue publicly. Affidavit of Desistance. It is a statement in writing where the complainant states that he did not really intend to institute the case and he is no longer interested in testifying or prosecuting. Reopening of the case. It is made by the court before the judgment is rendered in the exercise of sound discretion. It does not require the consent of the accused, may be at the instance of either party who can thereafter present additional evidence. Appeal. It is a proceeding for review by which the whole case is transferred to the higher court for a final determination. The right of appeal is a mere statutory privilege. Only final judgments and orders are appealable. Probation. The court may, after it shall have convicted and sentenced a defendant within the period for perfecting an appeal, suspend the execution of the sentence and place the defendant on probation for such period and conditions it may deem best. No application for probation shall be entertained or granted if the defendant has perfected an appeal from the judgment of conviction. Search warrant. It is an order in writing issued in the name of the people of the Philippines, signed by a judge, directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Scattershot search. It is a warrant issued for more than one offense. It is invalid because it violates what the law requires in a warrant of arrest. Search. Search is an examination of a man's house or other buildings or premises or of his person for the discovery of contraband or illicit or stolen property or some evidence of guilt to be used in the prosecution of a criminal action for some offense with which he is charged. Probable cause. It refers to the facts and circumstances which could lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place sought to be searched. Knock and announce principle. It states that an officer should knock, introduce himself and announce his purpose, and only in exceptional cases may he forego the same, like when his safety is in danger of being jeopardized or when evidence is about to be destroyed. Immediate control test. A search incidental to a lawful warrantless arrest may extend beyond the person where the exigencies of the situation justify a warrantless search for dangerous weapons and to prevent the arrestee from destroying evidence of the crime within reach. Stop and frisk operations. This is a limited protective search of the outer clothing of a person to determine the presence of weapons. Probable cause is not required, but a genuine reason, not mere suspicion, must exist, in the light of the officer's experience and surrounding circumstances, to warrant the belief that the person has concealed weapons. Fruit of the poisonous tree doctrine. The effect of an illegal search and seizure is the exclusion of the evidence obtained from being used against the person whose rights were violated by the search. Terry doctrine. A valid stop by an officer requires that he has a reasonable and articulable belief that criminal activity has happened or is about to happen. The frisk made after the stop must be done because of a reasonable belief that the person stopped is in possession of a weapon that will pose danger to the officer and other. Preliminary injunction. It is an order of the court to restrain or to cease from doing an act. Receivership. It is a remedy available to secured creditors to recover amounts under a secured loan in the event the company defaults payments. Repline. It is a procedure whereby seized goods may be provisionally restored to their owner pending the outcome of an action. Support pendant light. It is an order against the accused to provide support pendant light to the child born to the offended party allegedly because of the crime. The application therefore may be filed successively by the offended party, her parents, grandparents or guardian, and the state in the corresponding criminal case during its pendency. Attachment. It is a remedy afforded to the offended party to have the property of the accused attached as security for satisfaction of any judgment that may be recovered from the accused.